bail applications. You're probably panicking. If you're not, you're braver than some of us. I was in panic mode. Hi guys, welcome back to my channel. Igama AsandaNtini, and welcome to today's video. So if you are here, it's probably because you are a candidate attorney and it is your first time going to do a bail application, or you're here just for pure entertainment reasons. And remember, none of my videos are legal advice. If you are looking for legal advice, please go and find somebody who is supposed to give you a legal advice. Whoever that is certified to give you such advice. And with that said, let us speak about bail application. All right, before we get any further, don't forget to like, comment, and subscribe to this channel. And the first bail application that you're going to do, what do you need to expect and how should you go about doing it? Okay, the first thing first is this act. I'm trying to get it to focus. Is it focusing? Okay, the Criminal Procedure Act 51 of 1977. You must have it. If you don't have it in your phone, have it in your computer, even print it. Like, you need to have this because it's going to be your saving grace, because you're going to have schedules that are here. Schedules are in this act, and the section that you're going to be dealing with is specifically in this act. And the section that you are dealing with is section 60, bail application of accused in court. I'm not dealing with other bails. If you're looking for other bails, Chapter 9 of the Criminal Procedure Act, so from section 58 to 71, deals with bail applications. What I'm going to speak to you about here is bail application of accused in court. The first bail application, not bail on new facts, not bail after whatever, but we are dealing with the section 60 bail application. The bail which one is going to make in court, where the accused is going to make an application of in court. All right, what happens here? What should you do? Okay, the first thing that's going to happen is that you're probably going to be contacted by a relative or somebody who is not there, or the accused themselves will call you and tell you, okay, I've been arrested and I need you to do my bail application. What's the first thing you do? The first thing you do is go and consult with the person. If it means going to consult after hours at the holding cell, that's better. You're going to then have time to go and draft your affidavit the next day. Or if you're getting the instructions in the morning and the person is going to come in for the first appearance and it's not a schedule 1, 2, or 3 bail, you're going to go and consult with them in court. Please go and learn the different types of schedules. How do you calculate them? How do you determine this is a type of schedule? Because there are so many types of what's this thing? There are so many types of crimes, and they fall on different schedules, and different schedules mean different types of bail applications. Learn about the crime itself before anything else. That's your first point of preparation. Then you go and meet your accused. You get in there, you ask them all of the necessary questions. So in order for you to determine the necessary questions, you need to understand section 60 of the Criminal Procedure Act, because you need to answer all of those questions. The first one would be what type of offense is that? So if you're going to object, because the reason why you need to know that, say for example the state makes a mistake with the schedule, you can't object to it if you don't know what schedule it is. So if you know it's a schedule 3 and they're saying it's a schedule 5, you stand, you object. When you're making you object and say it's not schedule 5, and then you state your reasons, because you already know ukuthi yini. See? Okay, class. When you know And then you go to the accused, you ask them their full name, their address, you ask them all of their personal circumstances. Do they work? How much do they earn? How much can they afford for bail? Those are their personal circumstances, which you're going to use for an affidavit that you're going to prepare if you're going to be doing a Schedule 5 bail application. And then you ask them on affordability, you ask them on their address, and then you ask them all of the questions. Your section 60 will guide you of what you need to answer and what the application, what the court looks at when granting or denying the bail application. And then what else do you do? The next thing that you do is go and draft. You draft your affidavit, you prepare your heads of arguments, and then you go to court the next day if the bail is on the next day. So this is what happens in court when you get there to do your bail application. So say it's the first day and it's the first appearance. On the first appearance, especially if it's a Schedule 5 offense, the bail if it's a Schedule 5 offense, the bail hardly takes place on the first appearance. What happens is that you're going to get in there and the bail is going to be, the accused is going to be called, and then they're going to read the charges against him, and then they're going to ask him if he has legal representative or not, and then you obviously get on record, and then they're going to ask him if he's going to do bail or not, or they ask the attorney, and then yes, you stand and say the accused is going to be applying for bail, and then the state might request a postponement to probably confirm address, to prepare whatever, and then the postponement should not be more than 7 days. 7 or 10 days. Please read that up. No. But yeah, so the postponement would be about 7 days, and then if it's 7 days, and then on the 7th day, you're going to be coming back with your affidavit, your arguments if you want to prepare them. I like to write and I like to prepare, so I always had mine in writing because I stutter, and if I don't have things written, even though I know it even though I know it by my head, on the head or by my head, by the head. No man ngiyazi can't. I prefer to have something written so that I can guide myself. You can prepare one form of heads of arguments for bail, and you can use them for almost everything because you're just supporting your reasons for a bail application. So I'd recommend one thing that my principal taught me when I was first doing it was a labor matter. She told me to do, I was doing a retrenchment matter. Notice I know because it's the first arbitration I did. It was a retrenchment matter. So, okay, I'm sorry, I'll come back to that. So she said I must research all the information on retrenchment, what it is, case law, and put it in a folder somewhere and write it down if I'm writing. And I'm never going to have to go back and research for retrenchment unless there are new developments in the law. You obviously need to check that out. So the same thing you do with your bail. You go and research case laws on bail. What does the court look at when it's looking at bail? And then you have all of that in order to support your bail application. I'm not going to read you my heads of arguments. I'm not going to read you the cases that I've done because this is not a copy and paste place. Okay, here I'm just telling you what's going to happen in court. If it might happen this way, or this is just for entertainment. See, okay, the next thing that you're going to do, and then on the day that you're coming in, the day, you are the first person that's going to stand as the accused because you, as the applicant, because you are the one who's bringing the application in court. It's not the state that's bringing in the application. So this is what happens. You get in, your matter is called, and then to take bail application. The prosecutor is obviously going to call the case number, accused, puts you all on record, and then say it's a bail application that has brought everyone here. And then you're going to stand. When you're standing, you're going to then tell the court inform the court the accused has prepared an affidavit or you're going to put them on the stand. Wouldn't recommend putting an accused person, especially at bail stage, to go on stand. Don't do that to your client. But if you want, you can do that, but preferably prepare an affidavit. You prepare that, you read it for the record, and then once you're done, you say that that's the applicant's case, and then you sit. And then the court is going to accept the affidavit and put it as an exhibit, whichever exhibit it's going to call it, if it's A, B, whatever. And then the state is going to read an affidavit most of the time by the investigating officer, or call the investigating officer to read or prepare their affidavit and ask them questions. Usually it's when the matters are complicated or when the state is opposed to bail. And thereafter that, now it's the state's case. And then obviously the next thing is to prepare arguments. Then you go, do your closing argument. You state why do you think the accused should get bail. Bail is not what. The reason for bail is to secure accused appearance in court. So you state your reasons supported by your affidavit. Obviously you can't run away from it kakulu. You remind the court you can even remind the court what the affidavit said by obviously supporting it with law. And then that's it. And then the state also does their argument as well. And then it's closed, and then the court makes a decision as to does it grant bail or not. Usually asks is attitude the state is it opposed or not, and then also asks what amount does the state think should be given, and then the court decides. Maybe it could be more, it could be less, whatever, and then that's the bail. If it's granted, it's done, and then when or the client's family goes and pays for the bail, you get the receipt, the accused lives with you guys. That's how it goes. Yeah, that's the bail application. If it's a Schedule 5 or 6 application where you're going to have to bring in evidence. If it's not bail application, most of the time, the only thing that you need to prove is affordability, that the person has a physical address, and uguti, is there something that they are doing outside of court. Like the one important thing that you need outside of just being umahlalela, one thing that you need to be mindful of, somebody has to have a connection out with the outside, not outside of the country world, but say, for example, umuntu uyasebenza, so there are ties that he needs to fulfill. Uyasebenza unezingane. Those are things that you need to bring to the court's attention, because again, you're dealing with the freedom of movement, your mundu. You can't just infringe it when certain things are going to be affected. So that's what you bring to the attention of the court. So yeah, that's how you do a bail application. And what else? I've done many bail applications, but my very first one was horrible. One thing that I know, if I go back to practice, is my practice, I will do bail applications. One, they're easy. Two, they are not easy, but you don't need to know all of the evidence in order to do the bail application. That's one thing that I think lay people need to understand. How do you go about and do bail for umuntu? You don't know the whole thing. You don't know the whole evidence. The only thing that you know when you have not seen the docket at this point. So whatever it is, when doing the bail application, especially as a candidate attorney, do not address indaba evidence or whatever. You indicate that bail is not a trial or a mini trial, but it's rather to see if the applicant is a suitable candidate for bail. That's it. So when you're doing that, make sure you understand that, you fully understand the case against the crime that the accused is being charged of, because you won't understand the whole case because you have not seen the docket. The only thing that you know, and this is what the court wants to know. That's it. And what else? Do not panic. for the fact that somebody's life depends on you at that point. Yeah, it definitely does. But do not panic. Your client has to have confidence in you, so you need to be confident yourself. And yeah, I hope that this was somewhat informative and would help you in preparation for your first bail application. And if it's not your first bail application, you're probably panicking because your first one did not go very well. Go back to your drawing board, go back to your notes, do more preparation. Maybe you just were having a bad day that day, or the court was not friendly that day. Just go on, do the bail application. Not everyone succeeds at their first time. Not everyone succeeds every time. And it's work at the end of the day. You lose some, you win some. But one thing that I know is that you are capable and you're going to do very well in this. All right, I've spoken too much. And yeah, I hope you guys find this helpful, and I hope that everything goes well tomorrow or whenever that you're going to be doing your bail application. Anyways, don't forget to like, comment, and subscribe, and I will see you on my next video. Bye.